Congress.
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 Congress shall make no law.
Make no law respecting an establishment
of religion.
Or prohibiting the
free exercise thereof.
Or abridging the freedom.
The freedom of speech, or the press, or the right.
or the right of the people peaceably
assemble.
and to petition the government
A redress of grievances.
Hello, my name is Dr. Kevin Johnson, and I'm here today with Dr. Craig R. Smith to discuss his edited book, A First Amendment Profile of the Supreme Court. The 2000 presidential election marked a pivotal moment in contemporary electoral politics in America. While the public has certainly paid attention to controversial issues that have made their way to the court, the world turned its attention to the Supreme Court case of Bush versus Gore. A popular perception as a result of the 5-4 decision in that case is that the Supreme Court is an ideological court, one guided more by party or political beliefs than by equal justice under law. For the next half hour, we'll talk about whether this assessment is correct when it comes to the First Amendment. In doing so, we'll discuss the nature and scope of the way the current Supreme Court interprets the First Amendment. So let me begin with a question about the Supreme Court and ideology in the context of the First Amendment. But before doing so, I'd like to thank Dr. Smith for joining us today to be able to talk about this issue. Let me begin. Is it fair to assess the Supreme Court when it comes to the First Amendment based on ideological, liberal, and conservative lines?
Well, I think you're right to bring up Bush v. Gore because the 5 conservatives crossed over and overruled states' rights, and the 4 liberals kind of crossed over the other way and defended states' rights. So it looked like a craven decision. But I think in fairness to the court, they're less attuned to political ideology than they are to their own nuanced positions and how they rationalize their own cases.
Well, and the nuances, would you say that they're in all First Amendment or all cases in general, or are we particularly concerned with the First Amendment here?
I think they probably, you can generalize from the First Amendment into other cases as to the way the justices reach their decision and how they rationalize them. I think the First Amendment, because it's based on a fundamental freedom that we all have, is a good place to go to see how they work these ideological rationalizations out.
And one of the things that I learned with working on this project is that there's a lot of nuance when it comes to the First Amendment and the way that the court interprets them. And can we speak to some of the nuanced ways that constitutional interpretation proceeds? What are the kinds of ways that we went about studying them in this book?
Well, I mean, to give credit where credit is due, we used Philip Bobbitt's methodology. We started with that, and he is a noted teacher and legal scholar. And he establishes 6 different modalities to try and make a more subtle approach to the decisions by the court. The first one is historical, where they look at the historic context to determine how we should read the Constitution. Now, I mean, one way I think that the Supreme Court often goes is to say, if the language is clear, we'll go with that. But if the language is unclear, if it's a little nuanced, what do we mean by to assemble peaceably, then we go into the historical context and assess that. But the historical context also contains this notion of original intent. What was the intent of the people who drafted the First Amendment? And that's a little harder to parse out,
Right.
As you well know.
Well, and there's 3 different ways in which you can approach originalism. One is to say, let's take a look at the text itself, the Constitution, and the words as it meant at the time. Another way is to be able to take a look at other documents that may have preceded the Constitution, such as the Declaration of Independence, and how that may influence the constitutional interpretation. And then the third way is to be able to take a look at how the general public would have understood the Constitution at that particular time. Can you speak to some of the importances of these 3 very different kind of approaches to originalism?
Yeah, I mean, you know, here we have 1 of 6 modalities, and we're already splitting it 4 ways to Sunday. That makes it more subtle than I think even Bobbitt imagined. But it makes a big difference if you're a justice who says, I'm going back to the Declaration of Independence. I'm going to give it primacy over the Constitution, and therefore I'm going to look at the rights that were guaranteed in the Declaration of Independence, life, liberty, and the pursuit of happiness, for example. And that's going to override and guide my reading of the Constitution. And that's very different than somebody who says, well, I'm just going to look at the historical context at the time that the Constitution was ratified, and then 2 years later when the Bill of Rights was added to it.
Okay, so what are some of the other modalities that were?
Well, from the historical, the next would be textual, where we would look strictly at the text and we would ignore the historic side of things and just go with exactly what the text says. These are often called strict constructionist rulings when they rely on that. A third one is structural ruling.
Well, and in textual,
Yeah.
if I might stop you, there's
Sure.
two different ways. I mean, one is to be able to say, let's take a look at the Merriam-Webster's dictionary version of it and say, what does the word mean compared to the literal English word that's being used? And then there's another way as to how it's been used in the legal system, right?
Yes, and even a third way is to look at a sentence and contextualize it. And that becomes a different reading than if you take it word by word. I mean, to jump out of the First Amendment for a minute, when you look at the Second Amendment, the Supreme Court has been looking at it, the majority, has been looking at it word for word instead of contextualizing it in terms of the whole sentence. And you get a very different meaning between those two things.
Well, and it's, well, as we'll learn a little later, it's not just about context of the words themselves, but a context of the case itself and the willingness to look at the case. What's the third modality?
Absolutely. The third is structural. And this is, what happens here is when one branch of government is kind of pitted against another branch, and the justices have to work out a balance between them. If, for example, the Congress decides that it can overrule the states on certain issues, then the states fight back. You have a structural a fight there that takes place. It can happen within the government itself, whether the Justice Department has more primacy than the Department of Health, Education, and Welfare. So we're looking at the structure of the government, the framework of the government, and seeing how those structures fit together.
Well, and the structural would also apply to the differences within the document itself. So,
Right.
for example, conflicts over freedom of religion versus freedom of assembly versus freedom of press and so forth. There's some different conflicts that are embedded in the Constitution such that these values that are embedded in them, they come into conflict and they have to be weighed out at the same time.
It gets very complicated.
Yeah.
It gets very complicated.
So what's the next modality?
The next one that Bobbitt lays out is called the ethical. And he primarily looks at it from the focus of American ethos. What has emerged? How have our values changed? This warrants looking at the Constitution as a living document, looking at the Constitution in terms of penumbras, what implications are in there that we can go with, what's implied by this clause or that clause. That clearly brings the Constitution not only up to date, into modern times as a living document, but ethically, where are we and what should be allowed? If you look at the religious freedom clause, for example, in the First Amendment, do we now allow for same-sex marriage? Is that okay? Is that where our ethos is in America? And so the ethical standard allows you to update the Constitution and adapt it to modern thinking.
Well, and it's all, the key word here, if I'm not mistaken, is that it allows for us to interpret the Constitution as America matures.
That's right.
And so the metaphor here is basically like a child, where a child learns the very basic rules. You know, you shouldn't talk to strangers, you shouldn't eat foods that are bad for you, etc. And so you learn these particular rules. And then as the child matures, circumstances changes, you talk to more strangers, and you start to be able to account for those kinds of differences between the initial values and the way that we would mature as a democracy in America. Is that an accurate assessment?
Yeah, I think that's right.
Okay.
I think that's right.
All right. So
And then the fifth one would be doctrinal, and I think this is the easiest one to understand. This is where you rule based on precedent, where decisions have been made before and you use them as your guide. This is known legally as the doctrine of stare decisis, and many justices, it's very simple for them to say, we've already ruled on this, this is the precedent, I'm going to stick with that and apply it in this case too.
And as we'll learn, they're not always hip or keen to keep those particular doctrines that have come before them.
Right, and particularly a 5-4 decision where one judge flips, and you know that's not a very strong precedent, so maybe you want to flip that one back.
Okay, how about the next doctrine?
The last one is the prudential, and that is a cost-benefits analysis. This is often used by people who are sometimes called liberals on the court to look at what the the result is going to be of this decision? What's the impact going to be? What's the cost of it going to be? What's the benefit of it? And they balance those two and come to a decision in terms of the implications.
So one of the examples of that is that if a justice believes that their decision would set the precedent to overwhelm the lower courts with a flood of litigation, they may, even despite what they think is the right thing to do, say, we just can't do it. Is that correct?
That's right.
Okay.
And you get those tensions all the time on the court, as we'll see. Okay,
so all of these modalities then create a very complicated picture. Is there any relationship that we're able to identify between them?
Well, I think, what smart advocates do is see how they could build a consensus. What we discovered in the course of working on the book is that justices have certain foundational modalities, which is the most important thing to them, but they'll also use the other modalities for support. So someone may go with original intent and do a historic reading of the First Amendment, but they'll support it with precedent, or they'll support it with an ethical charge. So some of these things overlap and come together in all kinds of magical ways, but this is why in many cases you'll have a decision where you have 7 different opinions that are listed, some dissenting, some concurring, instead of just one statement as to what the law is.
Right, so let's talk a little bit about how these modalities then worked in this particular book, in a First Amendment profile of the Supreme Court. How did the authors proceed in terms of conducting their analyses of the justices?
Well, what the authors did was to do a close reading of what these justices had said on First Amendment cases, in First Amendment cases, and where were their rulings coming from. And they were able to look at the language that the justice wrote and to parse out which of the modalities this language fit into. And they did see that several modalities could be used at the same time. The other thing we did in the book was to go to their confirmation hearings and look at what they said they were going to do and how they were going to rule, and let that guide us also. So what you have in each chapter is a justice, their confirmation hearing statements analyzed as a clue as to where they're going to go. Then we have a look at their cases and how they ruled on those cases, and then we back off from that and look at which modalities are really foundational for this particular justice, which are in support and which are ignored. So it's a very complete analysis.
And so then in the end, we are able to get an idea of how each of the justices interpret the First Amendment, so that when people are advocating in front of the court, we can make a particular change in the strategies that we have available. Is that the idea?
Absolutely. I think this book would help lawyers, advocates in front of the Supreme Court, put together a consensus of 5 or 6 justices in a sensible way, rather than doing a scattershot case and hoping that they come together.
Okay, so this is fundamentally an interpretive kind of project where we're understanding what these justices are doing when it comes to the First Amendment, right?
It's an interpretive and a persuasive process.
Okay, and so what we'll do when we come back from the break then is we'll discuss some of the ways in which the different justices interpret the First Amendment based on these modalities, and we'll dive into all of the subtle nuances between these justices and then reach some general conclusions so that we can understand the ideological way that the court operates. We'll be right back.
The Center for First Amendment Studies conducts research on freedom of expression, religion, and assembly. Visit our website at www.firstamendmentstudies.org, where you'll find research papers and 2 e-books titled The First Amendment and the Media, as well as The First Amendment and Religion. The Center has also been proud to sponsor several major books by its director, Dr. Craig R. Smith, today's featured guest. The most recent include A First Amendment Profile of the Supreme Court, published by John Cabot University Press, and Silencing the Opposition, How the Federal Government Suppresses Freedom of Expression, published by the State University of New York Press, and finally, The 4 Freedoms of the First Amendment, published by Waveland Press. Each book is available at Amazon.com or the publisher.
Welcome back. I'm Dr. Kevin A. Johnson, and I'm here with Dr. Craig R. Smith. We're talking about the First Amendment profile of the Supreme Court. And one of the things that's interesting about this book is that we look at the confirmation hearings, we look at the majority opinions, we look at the concurring opinions, and the dissenting opinions. And I think that it's important to the reader as they're going through the book to understand that the majority opinions may be less important than the dissenting and the concurring opinions. Is that right?
That's right, because if somebody writes a dissenting opinion, they feel very strongly about it. So it's more indicative of where they're really coming from. If somebody writes a concurring opinion, it means I agree with the overall decision, but I don't agree with the rationale. I want to give my own rationale. So by going to the concurrences and the dissents, we get a much better idea of the values of that particular justice. And that's more useful to this project in the book than looking at their confirmation hearings, for example, where they're not answering questions and they're being as general as they possibly can be.
And the majority opinions, where when a justice crafts a majority opinion, they have to write it in such a way that the other justices that are in the majority will sign on to that opinion. So in that sense, they're trying to cater a lot of different reasoning and rationality that a lot of the justices would have.
Right. And I mean, to take you back to Bush v. Gore, Kennedy writes the per curiam overall decision, trying to cobble together some sort of majority to rationalize what they're doing in that very important case in 2000. Rehnquist is not happy with the way that's written, the Chief Justice, and so he writes his own concurring opinion explaining he would reach the same conclusion but through a whole different process. And so that's why I think looking at these concurrences and dissents is very important.
Well, then let's start at the natural place with Justice Kennedy. Some people have called him the pivotal vote on the court because he votes in the majority more often than any other justice on the court. So what do we have to say about Justice Kennedy? What is your reading of Justice Kennedy?
Well, I think Justice Kennedy is a very responsible justice. He uses the modalities that we've talked about, particularly the doctrinal. He goes from precedent when he can. But I think foundational, and you may disagree with me on this, but foundational to Kennedy is a higher law that's in his head. So I think we could put him in the historic category that reaches back to the Declaration of Independence, that sees certain natural rights out there that have to be defended. And sometimes that moves him to what the press unfortunately calls the liberal side, because the press isn't very subtle about this. But he sees a higher law every once in a while than the Constitution, and that's what you need to watch for in his rulings.
Has Justice Kennedy upset this conservative ideology in any way that you can think of?
Well, I think that, you know, he is trying to say that we don't only have to go with a strict reading of the Constitution, which would upset Scalia a little bit, and maybe Roberts, but there may be a higher law here that leads us to a different place. I mean, if you go all the way back to something like Brown versus the Board of Education, the desegregation case, they certainly went to a higher law. The constitutional issues there are very close. But when you go to the higher law of equal protection under the law and due process of the law, and translate that as pulling certain rights through the Constitution and applying them to the states, you get a different ruling.
Well, and I think that Justice Kennedy is appealing to a higher law when it comes to the First Amendment in terms of reinforcing the marketplace of ideas. Yeah. So a lot of his decisions are rooted in this kind of First Amendment notion that the ideas can circulate in the marketplace of ideas, and not just that consumers will be able to choose these ideas, but that these ideas should be put in contest with each other, the ultimate kind of debate model where if you contest different ideas, you can have a sort of enlightened truth that can come out of that situation. So I think that it's a fair reading to see Justice Kennedy as somebody who says, you know, these ideas may not be something that I particularly like or that are particularly beneficial to society, but if we just let those ideas out there, they're not going to be able to hold their water. Is that right?
Yeah, and I think he's also, one of the higher values he has is the right of the citizen to hear these things. And so for him, free speech means freedom for the public to hear the arguments, not just your right to make the argument.
And so the way that we're talking about Justice Kennedy then would be a very different way than we might talk about somebody like Justice Scalia.
Right.
Okay,
right.
So what are some of the ways that we might make sense of Justice Scalia in terms of his judicial philosophy?
Well, I think that Justice Scalia is grounded in original intent and grounded in textualism. I mean, he's almost a semioticist, the way he looks at the Constitution and the way he reads it. He's going to take the text, he's going to put it into the context of what he perceives to be the original intent of the people who wrote that amendment to the Constitution. So if it's in the first 10, he's talking about what was the original intent in 1791. If we're talking about the Civil War amendments, then he's looking at what was the original intent of the people who won the Civil War when they passed those amendments. And so he gets very strict with regard to historical and textual modalities.
Too strict?
Not for my taste, because I think that some of these modalities personally are dangerous because they allow you to reinterpret the Constitution in a plastic way, and once you start doing that, you begin to erode the Constitution. I like the way Scalia does it. I think he's very intelligent, and his decisions are very intelligent. They're also quite colorful because he knows how to use style and language. But I think what Scalia would say to some of the other justices is, if you don't like the Constitution, amend it. But while we have it, we have to interpret it very strictly.
Or they would say, or I think that Justice Scalia would say, it's not just about amending it, it could also be about relying on the Congress to be able to do these kinds of acts, right? That if you don't like the death penalty, have Congress pass an act that outlaws the death penalty. There's nothing in the Constitution that says that the death penalty needs to be permitted. There's nothing in the Constitution that says that the death penalty must be the way that we punish criminals. And
that's right. And in fact, it says we can't impose cruel and unusual punishment, and the death penalty probably is. And so I think that they would allow the Congress to do that.
But Justice Scalia said that it's not necessarily cruel and unusual because the founders of the Constitution were engaged in those kinds of acts all the time.
And that's a good example of where the ethos has changed over time, where now we might consider it a different way. And so you'd have another justice who is more on the ethical side rule the other way.
And yet there's a subtle distinction, I think, between justice like Scalia and Justice Thomas. Much of the public believes that they're basically the same. And indeed, there's good cause for that because they rule similarly in many different cases. However, Justice Thomas is concerned with the prudential modality a little bit more than Justice Scalia is. Is that a good assessment?
I think that's true. And I also think that Thomas, like Kennedy, is concerned with higher values, natural rights coming out of the Declaration of Independence. His historic approach is not only original intent, but he also looks at that higher law business. So sometimes Thomas and Kennedy are closer than Thomas and Scalia.
But I also think that Justice Thomas is concerned with the tradition of the court and being able to make sure that he's protecting lower courts from litigation. Justice Scalia may not have that same kind of issue. He may just be, you know what, the original intent of this was this. If the courts are overwhelmed, so be it.
That's right. No,
Okay.
I totally agree with that.
So then we go to what I would characterize maybe as the more prudential, pragmatic of the perceptually conservative justices, with Chief Justice Roberts and Justice Alito. Is there anything about them that are similar to the conservative ideology or different from that?
Well, I think Justice Roberts, as the Chief Justice, tries to be persuasive. Becoming a Chief Justice really changes people. Rehnquist, for example, was the Lone Ranger on the court until he became the Chief Justice, and then suddenly he was cobbling together majorities. And this ability of the Chief Justice to say, I'm going to write this case, and I'm going to try to persuade people to join me, or you're going to write this case because I like the way you think on it, changes them and gives them a lot of persuasive power on the court. I think essentially Roberts goes with precedent. I think he goes with strict constructionism in terms of reading things, and so that's why he's normally with the five that are called conservatives.
And we'll talk about some of the more subtle distinctions when we get to the cases in the second segment. But Justice Ginsburg and Justice Breyer would be a very different kind of interpretation than the previous justices that we've talked
about.
Well,
I think Justice Ginsburg, Ruth Bader Ginsburg, is a very interesting justice. In my opinion, she's the most liberal. She's the one who believes most in a living constitution. Her famous phrase about looking for a looseness in the joints so that everything can work together rather than crumble from friction is a way by which she rationalizes this kind of thing. She also seems to be less interested in the First Amendment than the other justices. She gives fewer rulings on the First Amendment than others.
So it makes it very difficult then to find out how she really thinks about the First Amendment.
Yeah, I think you have to go to the mirror of her other rulings in other cases, but you clearly see her consistently on the side of a living constitution, of changing the law to meet with contemporary demands, of looking at the implications of these decisions instead of reading strictly what the language says.
Well, do you think that this is an interesting reading of the 14th Amendment, the structural modality, that maybe the First Amendment isn't something that is of concern, and so when balancing the interests, the 14th Amendment seems to be a big priority for Justice Ginsburg? Is that accurate?
Well, I think the 14th Amendment has always been a rationale for those people who believe in a living constitution. It certainly was what the Earl Warren Court used to liberalize the law in America, claiming that they could incorporate the rights that were imposed on the federal government against the states. And that became known as the incorporation doctrine of the Warren Court. I think that's where Ruth Bader Ginsburg is. She pulls things through the 14th Amendment and applies them against the state and the federal government.
And what about our recent appointees with Justice Sotomayor and Justice Kagan? What are we to make of them so far? They're young in their tenure on the court. Is there anything that we can find out about them so far?
Well, Kagan was an advocate for this administration. She knows how the court works. She's argued before the court. And so I think you're going to see more pragmatism from Kagan than you might expect. Sotomayor, during her confirmation hearings, made some comments about affirmative action and ethnicity, and that as a Latino woman, she understood more about Latino women than white men would. I think that's a dangerous comment for someone on the Supreme Court, because you want to be objective in your interpretation of the law. And so I think Sotomayor, who has a good sense of humor and a feisty sense of style, may be the balance to Scalia. She may be the Scalia on the left.
Do you think that the prudential nature of Justice Kagan thus far might lead her to disappoint many liberals, maybe in the way that Justice Stevens disappointed many conservatives?
I think that's entirely possible. Yeah, I do. I think she could move in that direction based on her concern for the impact of the case on the lower courts.
So what do we learn about the overall schematic and makeup of the Supreme Court from this book?
Well, one of the things the authors did, the chapter authors did, was they sophisticated the Bobbitt model by bringing in rhetorical analysis, looking at the nuances of evidence, looking at the nuances of argument, looking at the persuasive strategies of the justices.
And so the ideological divide between conservative and liberal politics may appear firm, but the 6 modalities of constitutional interpretation reveal that there's a lot more subtleties involved in the way that we understand the First Amendment in the Supreme Court. Justice Ginsburg and Justice Kennedy, Chief Justice Roberts and Justice Scalia, and all the other justices are very different when it comes to the First Amendment. I invite you to read our book in order to find out some of these subtleties in the future. Thank you for joining us.
And a special thank you to the Long Beach Community Foundation for their generous support.